That's not even right.
Your rule.
There you go. There you go.
Senator Day.
Thank you. I have some questions regarding independent contracting. Just for background, I was the founding president of Independent Contractors of Australia, and one of our first goals was the introduction of the Independent Contractors Act back in 2006. And the purpose of the bill, as outlined in the explanatory memorandum, was, and I quote, to enshrine the freedom of independent contractors to enter into arrangements that are free from prescriptive workplace regulations. In other words, people who wanted to opt out of the regulated world of employment and enter into the commercial world of independent contracting could do so freely. My questions relate to litigation that the Fair Work Ombudsman has initiated against a company called Quest South Perth Holdings and Contracting Solutions for alleged sham contracting in relation to three casual cleaners at Quest Apartments who chose to become independent contractors. Now, I realise the Fair Work Ombudsman. Now, do I refer to you in the third person, or you are initiating litigation? Madam Chair, how do you want me to?
The
Fair Work Ombudsman, litigation is commenced in the name of the Fair Work Ombudsman, and so it is my title as well as the title of our office.
Okay, so I can say you or
you may.
Oh,
yes.
okay. Now, I realise you are appealing the Federal Court's June 2013 judgment in this matter, so I've framed my questions accordingly. But before I ask the specific questions, I note your litigation policy, which states that all Fair Work Ombudsman litigation-related activities should be transparent, accountable, constructive and effective. And in addition, all Fair Work Ombudsman litigation-related activities should be proportionate, consistent and fair, and conducted in accordance with the guidance note and the requirements of the Legal Service Direction. Now, in the Quest case, Justice McCarricher said of the three cleaners, and I quote, "I found they did become independent contractors voluntarily. In my view, they made a conscious choice to convert to independent contractor status. It was a positive decision taken by them." In short, the judge found the three cleaners were genuine independent contractors and that there was no sham contracting. Is that right?
I'm going to ask Ms Janine Webster, our Chief Counsel, to come to the table to talk with you about the details of the matter. Perhaps just to give a bit of context to our work in this area. Independent contracting is an important and legitimate way of work arrangement, and we have no arguments with legitimate independent contractors. As you've noted, the legislative framework does, however, provide for penalties where effectively what sham contracting is about is deliberately disguising what is, in actual fact, in substance, an employment relationship as an independent contracting relationship or a contract for services. And so we are very active in this space, but it is a tricky area for us because, of course, there are a lot of genuine, legitimate independent contractors and people who initiate that arrangement because that suits them. So we have a team called a misclassification team, which looks at the question of managers' complaints, if you like, around potential wrong classification. And it is an important area of our work. But having said that, it's not a huge area of our work. Less than 2% of our complaints are in this area. And so we do find that there's a lot of innocent or mistaken arrangements here where people are trying to be one and haven't quite made it within the scope of the common law definitions. Sham contracting is very deliberate behaviour, and the matters we take to court, and we have put, I think, some 6 sham contracting matters in court this year, usually involve pretty serious conduct that includes, it's wrapped up with other conduct like underpayments, phoenixing and the like. And so it's a very different sort of behaviour, sham contracting, from the legitimate kind of contracting that you're talking about. So as to the particular matter, I'm going to ask Ms Webster to talk to that. It is under appeal, so I'm conscious of that. But I think she would be able to explain to you the facts of the matter and the reason that we made a decision to appeal that matter.
Well, look, I'll repeat my question then, Ms Webster. That, do you agree with the judge that these cleaners were genuine independent contractors?
Thank you, Senator. If I can commence, my name is Janine Webster. I'm the Chief Counsel of the Fair Work Ombudsman. Senator, the answer is no. We don't agree with the findings of the judge, and that's why we made a decision to appeal that decision. And that decision is currently reserved. It was reserved on the 25th of February, and we're awaiting that decision. In terms of the decision to appeal the judgment, first, if I can just clarify, there are actually 2 cleaners and 1 receptionist involved in this particular matter. There were aspects where there were actually, the Fair Work Ombudsman was successful in the proceedings. There were proceedings brought pursuant to Section 357 and 358 of the Fair Work Act. We commonly refer to those provisions as the sham contracting provisions. As was indicated by Ms James, we look there not to just whether or not the employer has got it wrong, but also these other kind of acts of deliberateness, and that's actually an element, if you like, of these offences, or recklessness, which is turning a blind eye. We have, and I know that you're familiar with it, Senator, because you've already referred to it, we have a litigation policy, and Clause 9.5 deals specifically with the issue of whether or not we will take an appeal forward. We look at 2 issues. The first is the merits of the appeal, and the second is the public interest element. So it's very similar to the analysis that we'll undertake in deciding to even commence a proceeding at the outset. So that's the analysis that we undertook in the process of deciding to appeal this matter. And as Ms James has indicated, that matter is reserved, and we don't agree with the findings of the court at first instance.
The judge said, I find they became independent contractors voluntarily, made a conscious decision to convert to independent contract, and it was a positive decision. Do you disagree with that?
Well, it's not for me to go into the facts of the matter and into the particulars which are under appeal, Senator, but look, I think, as Ms James indicated, the types of matters that we put into court, we need to take into account all of the factors. I mean, this was a matter which involved relatively, if I can say, low level, or people who are more likely to be vulnerable, people in the receptionist role and 2 cleaners. And we took all of those matters into account, bringing the matter forward. We're concerned in the context of this particular decision that there is a long line of authority which deals with sham contracting and also, what kind of pressure has to be bared upon an individual before that kind of finding will be made. And, one aspect that will be considered is whether His Honour has erred. And I don't think it'd be appropriate for me to go any further into the detail at this time, Senator.
So you're saying that your office complied with your agency's litigation policy, that all litigation should be constructive and proportionate?
Yes.
How much has this litigation cost so far?
Approximately $60,000 in respect of the appeal at this time.
60,000?
In respect of the appeal.
For the department, the agency?
For the agency. That's an external expenditure, just to be clear.
Is that just the appeal?
That's correct.
No, the actual the case itself, the cost of the case so far.
I'd have to take on notice the exact figure, but it's approximately $350,000.
Do you know how much it's cost the other litigant in this matter?
I'm not aware of that, Senator.
If I said it was $800,000, would you be surprised at that amount?
I wouldn't be able to comment.
Are you able to provide an itemised list of the costs so far in this matter since you first initiated it?
I'd have to take that on notice.
Is it true that your office refused to tell the principals of Contracting Solutions exactly what your office was investigating and what Contracting Solutions was alleged to have done, despite repeated requests?
Senator, I didn't conduct the investigation. I'd be very surprised if that was the case, though.
Senator Day,
yeah, sure.
We will suspend for lunch. We will be back in an hour, and I will return to Senator Cameron for his line of questioning, and then you'll be able to return to your line of questioning following that.